Docket number SJC-13482, Commonwealth versus Kaiden J. Henderson.
Okay, Attorney Curran.
Good morning. May it please the court, Dana Curran for Kaiden Henderson. After David Trongo stabbed the victim in this case, on his way out the door, Mr. Henderson grabbed 2 bags that did not belong to him. The question underlying all of the issues I raise in my brief is, was this part of an armed robbery, or was this a larceny that took place after the fact and completely unrelated to?
So it's light most favorable, of course, as you well know. And the jury doesn't have to accept the defendant's story that he just mistakenly grabbed these bags. It could be that he purposely grabbed these bags, which happened to have the robbery proceeds in them, correct?
That's true. That's true. But I think then you look at the record to see if there's any evidence of an armed robbery. There's no discussion of a planned armed robbery. Commonwealth's witness, Trongo's girlfriend, testified that she wouldn't let him use her car if she thought there was a robbery.
What about the surreptitious parking job?
I have never committed an armed robbery.
Let's hope not, Mr. Curran.
If I had planned to commit an armed robbery, I probably wouldn't have my getaway driver sitting in the back seat smoking weed and on his phone. I think I'd have him in the front seat.
Well, maybe you would have committed a competent armed robbery, but I don't know. Mike, I guess I have a related question, which is, wasn't there evidence showing that he was, or at least from which the jury could infer that he had a knife in his pocket as he was entering the house?
I mean, and that's what the Commonwealth says.
Well, there's a video, right?
There's a video, and the video apparently shows a clip on the outside of his pocket. Now, we don't know what is attached to that clip.
But then
I've
when
never
he's
seen a lighter with a clip.
Well, I mean...
And then when he's coming out, he's holding not only the 2 bags, but he's also holding the knife? He's holding a knife?
I mean, I think you have to look at the video. I don't see it. I just don't. I've looked at that video 50 times, and I don't see a knife in his hand. I don't see, there's some kind of white object in his left pants pocket. The Commonwealth takes a position that his pockets were stuffed with cash. I can't tell what that is. It looks, I mean, when I first looked at it, it looked like a water bottle. I can't tell what it is. I can't identify that as cash. I can't identify a knife either going in or coming out.
How does he get blood on his pants?
The blood is bumped into the victim.
So he's in proximity to the victim.
Proximity to the victim.
Which isn't good.
No.
For sufficiency.
There are a lot of things that aren't good. I mean, you probably don't want to, I mean, had he not taken the bags, we would be having a different discussion. We may not be having a discussion at all. If you look at the video again, you see Trongo covered with blood. You can see visible blood stains on his hand, on his clothing. You don't see very much blood on Henderson. You see a little bit in the back. Well, I mean, you actually don't see it in the video, but there was evidence that there was some blood. But I mean, the Commonwealth also introduced 2 statements by Trongo. A statement to his girlfriend where he said, we were in there smoking and I was talking to the victim and we got into an argument and I blacked out and I stabbed him. He then, and you know, of course he has no motive to fabricate some kind of story. He doesn't say anything about an armed robbery, doesn't say anything about Henderson. He then talks to, a detective was talking to his mother, and during that conversation, Trongo calls his mother, and he overhears the conversation, and he said, I stabbed him. I it wasn't self-defense. Something like I flipped out and stabbed him. Same type of statement. Again, doesn't mention an armed robbery, doesn't mention Henderson's involvement.
Can I ask you about the lesser included offense
Yes.
of the larceny from person? As I read your brief, your argument is that's supported by the defendant's testimony. So
Yes.
there should have been an instruction to that effect. Since Brown eliminated second-degree felony murder, I'm trying to do the math as far as what the result is here. So you're saying the jury, if they believed this was a larceny from a person, not an armed robbery, would have been compelled to find the defendant not guilty of felony murder in total.
They could have.
Right, and that's the prejudice.
Yes, that's the prejudice. I mean, and most of these cases, Broom and I think Christensen, most of them occur in the context of second-degree felony murder, where
Right, that's why it's different here.
right, and a defendant says, I should have been given a lesser-included instruction on larceny occurring after the fact, and this court.
And what doesn't trouble me, but what I'm thinking if a jury didn't have that option, then they'd have to go to premeditation and/or atrocity of cruelty in a case where someone was stabbed 17 times.
Well,
And they could have found the joint venture.
I mean, the jury found him acquitted him of extreme atrocity.
Oh, no, they didn't. They didn't find extreme atrocity.
I'm sorry, they
cruelty.
didn't-
I mean, that's a big difference between an acquittal. They didn't. They bypassed atrocity of cruelty, and they bypassed premeditation.
They only
That doesn't mean
found him.
that doesn't mean an acquittal.
Well, it means that they didn't find it. Right. So I think they could have been, the only thing they convicted him of was felony murder. And certainly, had they been properly instructed, they could have said, well, he stole something, but it wasn't necessarily an armed robbery. And, I think that's the whole point. Had the jury been properly instructed, they could have acquitted him. So at the very least, he's entitled to a new trial on that basis. And again, you look at the language in all of those.
I'm having a little bit of trouble following that. We know that they rejected his testimony of events, right? We know that. And the jury were properly instructed on armed robbery. So if those two propositions are true, then how does your argument work about the lesser included?
Well, I don't think they rejected all of his testimony. They rejected that portion of his testimony where he says, on the way out, I grabbed what I thought was my own bag. Now, obviously, they could have disbelieved that and found that he stole the victim's bag or the two bags. I think given the choice, given their belief that he stole the bags, the only thing that they had in front of them was armed robbery. And they may have felt that that was the best fit for the fact given, for the facts given that he took the bags. But what if they found, consistent with that whole line of cases on second-degree felony murder, that he grabbed the bags opportunistically after the stabbing took place, and a stabbing which he didn't participate, he didn't know was going to happen, he didn't plan to have happen.
So those cases are applicable with the abolition of second-degree felony murder?
Well, I think the language is, because those cases say, this larceny didn't take, he went and took his wallet after he was shot, or he went and grabbed something and did this or did that after the killing took place or after the fatal injuries were inflicted. That was not accomplished with force.
So in the lens that we look at this, as Justice Walhoja was indicating as far as rejection of the defendant's testimony, because it wasn't requested, because there's no objection, it's a substantial likelihood, which gets us into the prejudice analysis, correct?
Yes. And, again, the prejudice is, had the jury been properly instructed on larceny occurring after the fact of a killing, but unrelated to it. They may very well have said, okay, yeah, he took the bag. Maybe we convicted him of larceny if we're instructed on it, but we don't convict him of armed robbery or felony murder.
Opportunity to choose robbery versus unarmed robbery? Robbery versus armed?
I don't believe so. I think it was just armed robbery. And, you know, I think trial counsel did a good job with the mechanics of trial, cross-examining witnesses, things like that. But I can't understand some of his legal decisions. And, you know, in particular, he conceded in his motion for required finding that the evidence supported armed robbery or felony murder. I don't know how you don't argue that. And I also don't know how you argue that, you know, for example, there should be an instruction on larceny after the fact, because really there is a very, very plausible scenario that after the killing took place, that there was a theft, but it was unrelated to the killing, and it was not accomplished by force. He just grabbed the bags on the way out the door. The Commonwealth doesn't address this issue in the brief, but
That's the question we're going to have for counsel.
yeah, I mean, I think they have a theory that Henderson participated by actually doing the stabbing, and I don't see that as supported by the record. The medical examiner never testified that there were two knives. The medical examiner testified that there was some wounds that were sharp, that were slices. There were some that were sharp and that were puncture wounds, and there were some that were sharp and then blunt. But that would be consistent with my suggestion is
There was no direct testimony about two knives.
no.
There was testimony about the sharp force injuries having different characteristics, that being two different types of edges, correct?
Yeah, and I think that's consistent with a knife that may be sharp.
Well, that's your view of it. So now it's light most favorable.
Right, but like most favorable, I mean, they never asked the question. They never asked the question in the medical examiner, could that be two knives? And there's
So you're saying that that's too speculative to support that?
absolutely. So, but then looking at the and the whole thing about the running out with cash, you know, these defendants were all arrested. The other two within a couple of days, and my client with about a little over a week later. Nobody had any cash, and Devon Johnson was on the phone with his brother saying, "You got to come up with some money so the guy I got popped with can get out of the state." You know, there was no money taken. There's no evidence of any money taken there. And how does this make sense where Henderson buys marijuana from the victim, gives him $50, and then the victim puts it in the safe, and there's $2,700 in the safe? Why wasn't, if it was an armed robbery, why didn't that happen right then?
What's in the bags that were stolen?
There's some suggestion that it's marijuana. And, you know, I think I'm not defending my client's theft of that.
No, I don't really care about the moral combination. I'm
Right.
more concerned about whether they're proceeds or not. And it seems like they may not have taken the cash, but they took something, and that something being the weed.
Well, they took the weed, but, you know, that doesn't seem to have generated a lot of cash. And again, if he hadn't taken the bags, I think we would be having a different conversation. But how do we reconcile all of that where the jury was never instructed? If you do a word search in the entire transcript, you won't find the term larceny. I think the judge should have picked up on it and said, you know, this may fit into this whole line of cases where there's a larceny that took place after the fact of the murder and not accomplished through force.
It's not up to the judge to figure out what the defendant might benefit from, right?
I think it is. If the law requires or supports a particular theory, I think it's up to the judge to give that theory.
Without
Yes.
sort of having,
I'll give you an example. Commonwealth versus Waller, where Justice Gaziano was the trial judge. There was
oh, isn't that?
Always fun.
yes, there was some testimony.
I hope I wasn't reversed.
No, you weren't. But there was some testimony that there was something in the victim's hand as the defendant approached him, and that could possibly have been a weapon. And Justice Gaziano said, based on that testimony, do you want an instruction on self-defense? Unfortunately, my client's trial counsel didn't. That was a problem. But the point is, it is up to the judge to say, okay, you guys haven't told me that you want this, but here's an issue that seems to be supported by the
There's
evidence.
a difference, though, isn't there, between having a judge who is a particularly good one and can, look at things and say, this is something I want to make sure we cover, versus it has to be done or else it's error.
Well, maybe it doesn't have to be done in every case, but in this case,
No, I'm not, I think you're right. It would have been great had it been done.
it would have been great, and it also raised a real possibility of an acquittal because, again, if the evidence doesn't require dismissal based on an insufficient evidence of an armed robbery, the evidence of an armed robbery, there's no evidence of a planned armed robbery, it certainly would have supported that. And had the jury said, okay, this is just a larceny, then, he does 2.5 years in the House of Correction or 5 years in state prison and he's done. So that really is my
I guess I'm having a little bit of trouble getting to the last part of this, which is the prejudice piece, because the jury did not credit the defendant's version of events. The jury were instructed that on the elements of armed robbery, and were told that in order to find felony murder, the death needed to be caused during the commission of the felony, which is armed robbery. If all of that is true, and that we accept that the jury follows the instructions, then if they had credited the defendant's testimony that it was just an opportunistic mistaken taking of the duffel bags or whatever after the fact, then they would have acquitted him had they followed the instructions. So where do you get the prejudice from the absence of a larceny instruction?
I think the jurors were only given one way to look at this. And it is, and I think if they had been given a second way of, okay, there was a stabbing that took place, committed by Trungo, and subsequent to that, there was a taking of a bag, of the 2 bags. If you find that, you have to acquit him of felony murder, of the armed robbery. And, it's not a question of were they compelled to? I don't think they were, but they had that option. Well, actually,
Here they had the option of convicting him only on one theory. And you're saying it would have been better for him to have given the jury the option of convicting on an additional theory as well.
well, I'm not sure if you convict him, maybe because larceny is a lesser charge of armed robbery, maybe there's an instruction on that. But as far as felony murder, if it's only a larceny and not a robbery, an armed robbery, then they have the option of acquitting him. And they may, on these facts, they may very well have done that. On the testimony of, on the statements by Trongo, where he took full responsibility and did not implicate Henderson, and there's no evidence of a plan, and it just, the whole armed robbery thing is just, it's sort of a red herring. I think that's where the prejudice is.
Okay.
Thank you.
Thank you. Attorney Moriarty.
Good morning. May it please the court. Marina Moriarty on behalf of the Commonwealth. With respect to the issue of the lack of instructions on the lesser included offense of larceny from a person, even in the light most favorable to the defendant, there was no larceny from a person and therefore no reason to give that instruction in this case, even if it had been requested. The defendant testified that in the dark, in his escape from the room, he took his bag, which he had testified that he left there a month or so ago, and accidentally took the victim's bag. So therefore, the defendant's testimony unambiguously creates no larceny.
There was no intent to deprive another of their property.
Correct.
It was a mistake of fact.
Correct. And he testified to the mistake of fact. So therefore, given the defendant's testimony, there was no rational basis for providing the lesser included instruction. A case I did not cite in my brief, Donlin, 436 Mass at 337, says the judge need not reconstruct all factual scenarios subsumed in the evidence and charge accordingly. Therefore, the instruction need not be given if it would distort the testimony. Moreover, there was no request from defense counsel. That's undisputed. There was no motion for a new trial in this case, so we can conclude that it was likely a strategic decision where the defendant himself did not testify to those facts. The defense wanted the jury to credit the defendant, which would have...
It would have been better if you had briefed this and we've gotten that argument.
I apologize, Your Honor. I do. I missed a nuance. But I think in this case, this is an armed robbery case. Defense counsel viewed this as an armed robbery case. Defense counsel wanted to argue to the jury, and in fact did argue to the jury, that they should wholesale believe the defendant's testimony. There was no reason for him to, this all or nothing defense is something that this court has approved of multiple times in the past. Defense would have had to argue in the alternative to get the larceny conviction. He would have had to say, well, you should believe my client's testimony. He didn't know about the robbery. He didn't stab anybody. He didn't mean to do anything bad. But, he was wrong when he testified that he didn't mean to take the bag.
Is the video evidence so unclear that it makes the Commonwealth's argument speculative? I've got still photos of the clip.
Your Honor, the Commonwealth did submit the compilation video in.
Yeah, I didn't watch the video. I've just got still.
So it is very clear. It is very clear the defendant has nothing in his hands when he is walking into the building. It is very clear, and you can see the Commonwealth argues a knife in his right pocket, and it's very clear as he's leaving that over his left shoulder.
So now the knife in his pocket is something that's clipped in.
You can see the exterior clip of the knife in the right pocket.
Wait, you keep saying the knife. You can see a clip of something in his pocket. And I understand that the argument is that it was a knife.
Correct.
Right.
So you can see the clip, which the Commonwealth argued, and there was no objection to the argument in closing that it was a knife.
Well, that doesn't make that evidence. That just makes it that's the Commonwealth's theory.
I think it's a fair inference and it's a conclusion that the jury can draw that it is a knife, because then when he's leaving the apartment, you can see over his left shoulder are two bags. You can clearly see that there are two bags. And in his right hand, the Commonwealth's argument is that it was a knife. The defendant testified that it was a cell phone, but the Commonwealth suggested in its closing that it was not glowing like a cell phone. It was not being held like a cell phone would be held. Moreover, it is consistent with a knife because the Commonwealth's argument is that you can see that the defendant's pockets are full, and so therefore the prosecutor argued that the defendant would have taken the knife and put it in the small of his back, which would account for the victim's blood being in the interior waistband of the defendant's underwear.
Can I ask about the video when they go in? Can you tell whether there's something in his on the way out, his pockets are full, you say. Do we know what the video shows going in?
It appears that the only thing you can see in his pockets, that he's wearing like black skinny jeans. The only thing you can see, I would suggest, is the clip. I would also suggest that it's pretty clear that when he parks around the corner and leaves the car running with the person that is most known to the family in the back seat of that car.
Although he's well known to the family too, right?
He is known to the family, but
He's close friends with the victim.
Victim, correct. However, co-defendant Johnson was most known to the family, and the victim's dad testified that Devon Johnson actually ate food off his plate. So he stayed in the car. The other two went up. The defendant put up his hoodie, put on a COVID-style mask before he went into the apartment. The victim was waiting for him. They went inside. Co-defendant Trongo had to go settle his nerves. The victim's sister testified that he went to the bathroom and washed his hand, but she didn't hear the toilet flush. When he came back shortly thereafter, there was the commotion. The defendant and Trongo sprinted out back to the waiting car. Devon Johnson opened the door for the defendant to get in the front seat, and they sped back to the hotel where the defendant had expected customers to arrive to purchase marijuana. The defendant himself testified that he needed the marijuana from the victim in order to sell to waiting customers. He testified to that on cross. I would also suggest that there was testimony that the victim had $30,000 in cash in his bedroom. The victim's dad testified that he just sold a car and had been running some sort of mechanic business, and that was the reason for the money. With respect to the knife, again,
Sorry, but that money was not taken, right?
the money was never recovered. Correct. There was,
So there was money that was there that was not found in the safe?
correct. According to the victim's dad, he would have had $30,000 additional, and I think it was about $2,700 in the safe, the locked safe.
One of the witnesses describes them as having a lot of money, right?
Yes, the victim's dad, in the back in the hotel room, the customers for Devon Johnson said that they had a lot of cash. I would also suggest that the two different types of knives is a very fair inference from the ME's testimony. The ME testified that you can make some conclusions based on the type of stab wound, whether it's sharp or sharp blunt. She said you can make a conclusion about the instrument that is used to do the cutting. Here,
Wait, yeah, so that means it could be a knife with a sharp edge and a blunt edge.
correct, but she testified to, with respect to the 17 wounds, there was a number that she described as sharp, and there was a number she described as sharp blunt, including the neck wound. And there was 3 she described as sharp.
He doesn't use single-edged or double-edged, right?
She doesn't use those terms, no. So with the medical examiner's testimony is consistent with 2 different types of knives being used to inflict sharp blunt wounds and sharp wounds. The sharp blunt wound is consistent with the knife that Trongo used because Chris Lewin testified that he observed Trongo with a steak knife. And the sharp blunt stab wound was to the neck, and Trongo told Stacy, his girlfriend, that he stabbed the victim in the neck. So all of that lends to the prosecutor's conclusion in closing that the defendant was responsible for the 3 sharp wounds.
What was the evidence of what was in the bags that were taken?
Marijuana and money. A significant amount of exotic type marijuana specifically.
Okay, there was testimony precisely about both of those?
Yes.
Okay.
The testimony about what the two buyers and the girlfriend saw when they got back to the hotel room. And I would again suggest that where the defendant, there's consistent evidence that the defendant committed the stabbing himself in conjunction with Trongo, that certainly satisfies the malice that would be required under felony murder,
It would at least be third prong.
at least.
Can you talk a little bit about the evidence that there was an intention to rob the victim?
Sure. So the testimony was that the group knew that the victim sold marijuana.
Okay.
There was testimony that the defendant needed marijuana to sell to his own customers. So the testimony was that the three were going to, the defendant said that he was just going to buy $50 worth of marijuana. The jury rejected that view. Rather, the plan that was formed in the hotel room or in the car on the way was that they were going to the victim's home where they would be expected to meet resistance. Both of them were armed with knives. The defendant parked the car, not in the nearest spot, but around the corner. The two people that were least known to the victim and his family were chosen to go up to the apartment. They concealed their faces.
Can we just go back for a second? So you said that there was a plan to rob the victim and that the victim, because they were both armed, but that's inferring that the clip that was seen in the pocket was a knife. That's how we know
Yes,
he was armed.
yes, and I think that's consistent with the DNA evidence, consistent with the ME and the ME's evidence about the two different types of stab wounds.
But the ME did not testify that there were two different knives.
Not specifically, no.
Okay. And
So once they got up to the apartment, it was clear that the victim was waiting for them. So they had planned. This wasn't a surprise. The victim's younger sister said, "Oh yeah, I opened the door, and then just a second later, my brother came out of his room, and they all went in the room."
and that shows
some sort of coordination that the defendant and Trongo had communicated with the victim, and that he was expecting them.
yeah. Well, that doesn't prove the armed robbery, does it?
No, but I think in conjunction with all of the circumstances put together, the fact that then the victim's younger sister described Trongo as skitterish, the fact that he went to wash his hands, that he went back, and then is when they stabbed the victim and robbed him of his money and marijuana.
I'm trying to make sure I understand the connection between the defendant knowing that there's an armed robbery, that there was a plan for an armed robbery, versus Trongo deciding that that's what he was going to do.
Well, he's the one who had the motive because he needed.
Well, I'm sorry, they both wanted marijuana, right?
Well, we don't know what Trongo never said one way or the other. The defendant in his testimony said he wanted marijuana.
Which he was going to buy.
That was his testimony. But he also admitted that he contradicted himself in a way on cross-examination when he said, yes, I had customers waiting at the hotel. I needed to get marijuana to sell to them.
And that was a contradiction? I'm sorry.
Because he wasn't just going to buy it for himself. He's not just buying it for personal use. He needs not just $50, not just 7 grams of marijuana. He needs a substantial amount of marijuana in order to sell to his customers at the hotel. So he's the one who had the motive. He's the one who drove the car. He's the one who parked around the corner. He's the one who put up his face mask. He put up his hood. He's the one who was armed. So I think all of those elements together, individually they may not be sufficient, but together in the light most favorable to the Commonwealth, certainly show a plan to commit an armed robbery when they walked into the victim's apartment. And I would just point out, just in totality, so it's the court's aware, that this is a jury that was discerning. They found the co-defendant, Devon Johnson, not guilty of accessory to the fact after murder. They found him only guilty of accessory after the fact to armed robbery. So I would suggest that this wasn't a jury that felt compelled to, to convict one way or the other. And admittedly, there was less evidence with respect to Devon Johnson and his participation in the planning of this armed robbery than there is of the defendant, who had the motive, who drove the car, who went to the apartment with a knife.
Is there any evidence, anything in the record about what happened to Trongo? I know.
The record is that he was deceased prior to trial. The fact is he committed suicide in jail prior to trial. If the court has no further questions, I'm happy to rely on my brief.
Thank you.